Mr. President, it was 11 years ago that I wrote a letter to John Roberts, the Chief Justice of the Supreme Court, 11 years ago, asking him a basic question. Mr. Chief Justice, why is it that you believe the 9 justices that sit on the Supreme Court should be treated differently than any other person in federal government when it comes to the code of ethics? I didn't receive a reply to that letter. We know what's happened since. Through private investigations and investigations by journalistic organizations, we have come to discover that at least one sitting Supreme Court Justice, Clarence Thomas, has received more than $4 million in gifts from billionaires. What kind of gifts? Travel. Jet airplane travel, travel on yachts, long-term vacations, worth more than $4 million, largely undisclosed to the American public. What's going on here? A justice on the Supreme Court receives over $4 million in gifts from billionaires and doesn't disclose it to the public? What about other federal judges in like circumstances? Do they have requirements when it comes to the gifts they can accept and what has to be disclosed? Of course they do, in detail. It's only the 9 Supreme Court justices that have exempted themselves from the basic, enforceable, transparent code of ethics that applies to every other federal judge in America. So when my friend from South Dakota comes to the floor and says we're being too critical of the Supreme Court, $4 million in gifts? If any member of the Senate received that kind of largesse, they would be held responsible for it under the law and should be. Secondly, this notion that being critical of the Supreme Court is somehow critical of the institution. I do raise questions, and I will in the statement I'm about to make this morning, as to some of the most recent decisions. I think they're terrible. I think in terms of their impact on the future of the court and the future of the Constitution, we have legitimate concerns that should be raised. But to raise those questions is not to attack the integrity of the institution of the court, but the process and the decision-making that the court has made. Of course, throughout history, there have been times when the courts just plain got it wrong. Plessy versus Ferguson, a case which dominated for decades and said that separate but equal was acceptable under the law. It wasn't until Brown versus Board of Education in the 1950s that they finally reversed that. For decades, Plessy, this terrible, wrong-headed decision, governed the administration not only of justice but of education in America. It damaged and destroyed lives right and left. Were people critical of it? Yes, and they should be. We are living in a democracy with freedom of speech, and we should be able to express ourselves when we have serious misgivings about decisions by the court. I want to address 2 recent decisions by this court that I think really deserve special attention. The court recently finished its term with a series of disastrous decisions that once again upended our constitutional landscape. The court's radical, conservative supermajority discarded decades of long-standing precedent to protect rich and powerful interests. The court's decisions will immunize presidents who commit crimes. Let me repeat that. The court's decisions will immunize presidents who commit crimes, make it harder to prosecute corrupt politicians, and make it easier for corporate special interests to overturn federal protections that Americans need to remain safe and healthy. Meanwhile, the court's conservative supermajority failed to protect some of the most vulnerable, upholding laws that criminalize homelessness, denying Americans the right to challenge the government when their immigrant spouses are denied a visa. The far-right justices responsible for these decisions may claim they are guided by textualism or originalism. We hear those terms frequently. But the reality is that they're engaged in judicial activism, pure and simple. The justices are cherry-picking their way through the constitutional text and history to impose their own ideological agenda on the American people. And in doing so, the majority has not only further damaged the Constitution's institutional integrity, they have undermined our democracy. Start with the court's ruling in Loper and Relentless. In these cases, the court overruled Chevron versus Natural Resources Defense Council, a landmark 40-year-old decision holding that courts must provide deference to an agency's reasonable interpretation of ambiguous federal law. With authorization from Congress, scientists, engineers, and other experts at these agencies use their expertise to establish rules that help to ensure our food is safe and medications are effective as promised, We have clean air and water, stable financial markets, fair working conditions, and war. But after the court's decisions to overrule Chevron, unelected judges with no expertise will be empowered to overturn rules issued by agency experts when they are challenged by corporations. In another case, Ohio versus EPA, Justice Neil Gorsuch inadvertently demonstrated how ill-equipped the judges on the court are to substitute their judgment for agency experts. In an opinion siding with Republican states that challenged an EPA pollution control plan, Justice Gorsuch repeatedly and incorrectly referred to nitrous oxide, which is laughing gas, as we know, rather than nitrogen oxide, the pollutant that the EPA is seeking to control. So the court was arguing that the agencies didn't have the power to make these decisions in detail and failed to describe properly the exact entity that was being regulated by the EPA. The court's decision giving justices like Justice Gorsuch the power to second-guess these agency experts is a body blow to our government's ability to protect health and safety of the American people. In another misguided opinion, the court's 6 Republican-appointed justices ruled in Trump versus the United States that a president may be immune from criminal prosecution for abusing the power of government for personal or political gain. This case is unimaginable. Specifically, the court held, and I quote, "The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all his official acts. Not only does the decision bar prosecuting a president for any official acts, it prohibits prosecutors even from using any official acts as evidence to help prove a president engaged in illegal, unofficial acts. And in ruling that Donald Trump is, quote, absolutely immune from prosecution for the alleged conduct involved in his discussions with the Justice Department, the court has given a green light to the future president to use the Justice Department for corrupt purposes. The Justice Department, whose mission is to enforce the law, defend the interests of the United States, and ensure public safety, will no longer enjoy its traditional independence. It could instead serve as a weapon to be wielded by a corrupt president. So what does all this mean? It means that a corrupt president may hide behind their office for protection from prosecution under the law for even the most egregious wrongdoing. It means the Supreme Court's conservative majority has effectively endorsed Richard Nixon's infamous claim that, quote, when the president does it, that means it's not illegal. In fact, much of the conduct at the heart of Nixon's Watergate scandal could arguably be considered official acts, making them presumptively immune under current interpretation. And in the aftermath of Trump versus the United States, a court would not even have been allowed to question Nixon's motives in order to determine whether he acted unlawfully. The court's ruling has also left Congress and the judicial branch with limited options dealing with a delusional or corrupt executive. The minority leader stated during the second Trump impeachment trial, we have a criminal justice system in this country, we have civil litigation, and former presidents are not immune from being accountable by either one. Unfortunately, this is no longer the case because the court's conservative majority has demolished the ability to hold any president accountable for abuses of power. Excuse me. It was not long ago that then Judge Roberts sat before the Senate Judiciary Committee and told me directly and personally, I quote, no man is above the law. Then Judge Gorsuch also testified, and he said, nobody is above the law in this country. And then Judge Kavanaugh told the committee, and I quote, no one is above the law, and that is just such a foundational principle of the Constitution and equal justice under law. But now they seem to think that a corrupt president is in fact above the law. When the American people head to the polls this November, they should keep this case of Trump versus the United States in mind. We must ensure that our next leader is a person who will respect the rule of law even though he is now, because of the Supreme Court decision, immune from prosecution. Mr. President, I yield the floor.